Um, I am honored to be the chair of this panel, or of any one of the panels, but for various personal reasons, this panel as well, especially. I'd like to make two comments. First, I want to congratulate the Law Review, and I want to thank the contributions of my colleagues here and Dr. Dunn. I think it's great that this is a combination of Case Western Reserve University and Cleveland State University, and we don't do that enough. I'm not going to introduce the panel because I could go on all day. I didn't meet Professor Whitmer Rich until last night, but I've heard of him since he's been at Cleveland State. Actually, I'd heard of him when he finally escaped from Jones Day and went to the Federal Public Defender's Office. Michael Benza is my co-conspirator in crime. We're next door to each other. We scream at each other every time we come across a ridiculous opinion. He's my conservator also. And then at the end of the table
At the end, right.
is
End
one
slice.
of my oldest friends in Cleveland, the lawyer's lawyer, the great man in civil rights and criminal defense, and my model as a criminal procedure teacher.
Oh, I tell my classes, you're my model.
Well, maybe we'll keep going for another 40 years this way.
So it should be done.
The panel has decided they would prefer to speak from up here. I would just like to introduce the subject matter of this panel, a little provocatively. The subject matter of this panel is the Equal Protection Clause and the fading Fourth Amendment protection. And of course, Whren plays a huge role in the issue of the fading Fourth Amendment. And as Professor Harris pointed out, then came along Atwater, which was the death blow by supposed liberal Justice Souter, the worst decision he ever wrote. In Whren, Justice Scalia says, well, you have no remedy under the Fourth Amendment. He doesn't tell us why. He doesn't tell us why the exclusionary rule of the Fourth Amendment is not applicable to the violations in this case, although he claims to agree with the petitioners that race-based stops are unconstitutional. But he says, go seek justice under the Equal Protection Clause. Cynically, he knows there is no exclusionary rule under the Equal Protection Clause, except in the state of New Jersey. So with that background and introduction, I'm pleased to introduce to you Professor Whitmer Rich.
Thank you very much. So it's an honor to be here. Thank you to Ellen and the Law Review students and to everyone at Case Western here for organizing such a tremendous conference. It's really an honor to be here. So I think I'm going to continue the discussion about the fading Fourth Amendment, and then we're going to turn to Gordon, who's going to talk about the equal protection issue, and then Michael Benza will wrap it all up one way or the other. And I want to begin by, I think the issue I want to address has been framed very well by Lewis Katz and by David Harris and others. which is we've got Whren versus United States, a short unanimous opinion, which they're now describing as this kind of centerpiece of this, the role that the court has played in diminishing Fourth Amendment protections and enabling the war on drugs and all of this kind of stuff. And Professor Harris in particular put it in line with a lot of other decisions in the Fourth Amendment. The puzzle, I guess, is that a lot of those other decisions have dissents, right? So as we've heard the questions, right, where was Justice Ginsburg? Where was Justice Stevens in this case? Why is this a short unanimous majority opinion? And that's what I want to try to think about a little bit. I believe that a big part of why the opinion is the way it is that I think even the liberal justices looked at this issue and they kind of thought, well, what else could the rule be? I mean, the police see somebody commit a traffic violation and you, the petitioner, are asking us to say one way or the other, you can't pull them over or something, I'm not sure what, right? What else could the rule be? The police see a traffic violation, they can do a traffic stop if they want to. Now, Margaret Lawton and maybe others are going to have written and are going to talk later about other approaches to this, like an objective reasonableness test, and which the court, I think, dismisses kind of out of hand, but, is that realistic? Could it really work? And I want to talk about an issue that I think is buried in that, and so I want to introduce it, I guess, by kind of telling a story. I think it's the fundamental framework that even the liberal justices were not recognizing in this case, and the story, to veer off for a moment, if you'll indulge me, is this. So I teach, among other things, criminal procedure. This fall I'm teaching it at 2 o'clock in the afternoon on Tuesdays and Thursdays. I have a syllabus, of course, and the syllabus says class starts at 2 o'clock, and if you're late, you can be, I can count that against you in your class participation grade, and I tell my students class starts at 2 o'clock, I expect you to be here at 2 o'clock. So the first couple, week or two of class, you get a few chagrined students coming down at the end of class, kind of meekly apologizing for why they were 2 minutes late or walked in a minute late, and I kind of reassure them it's okay, it's fine, I'm not a ridiculous person, I'm not gonna, it's okay. And, after a couple weeks, they realize that the 2 o'clock starting time, there's a buffer zone there, right? I mean, if they walk in 2 minutes late, they're not gonna, so there we go. So let's say near the end of the term, right, we're starting to get late in the term. One of my students comes in and she's 2 minutes late and she kind of, smiles meekly and as she goes and sits down to her seat. And then afterwards, as she's going out, I say, just so you just lost 5 class participation points for coming in late today. And she's kind of shocked and embarrassed. And then afterwards, when she leaves and she talks to her friends a little bit, she realizes she's not so much embarrassed as angry, right? And that I'm being kind of ridiculous. So, she asked me to change that decision. I say no. She petitions the Academic Standards Committee. And the Academic Standards Committee is trying to determine whether my actions were reasonable or not, right? So am I being reasonable or unreasonable in that? Well, obviously, I'm being unreasonable. Why am I being unreasonable? Imposing that sanction on her was arbitrary, right? I wasn't imposing that sanction on all of my students. I told them what the rule was, but then I made it pretty clear through my behavior, my enforcement practices, that in fact there was a de minimis buffer zone there, right? And as long as you were within that zone, you weren't going to get penalized. And then arbitrarily, I changed that and enforced the rule against one person. That is the story that is missing completely from the majority opinion, from the unanimous opinion in Whren versus the United States. Arbitrary law enforcement is unreasonable. That's easy. We can establish that. We could cite a lot of cases, but there's plenty of cases that say that. The next step then is, the court kind of acknowledges, and David Harris mentioned it, that, well, the traffic code is so long and complex, it's really impossible to comply with every single component of it, and there's some truth to that. But there's a deeper truth, right, which is one of the big reasons that there's rampant non-compliance with the traffic code is that the police do not expect us to comply with the traffic code, right? They systematically, through their policies and procedures, do not enforce the traffic code as written. There, I haven't had any luck yet finding, at least in the United States, any very clear written policy on this, but it's clearly in practice, right? I found in England, there's actually a written policy on speed limit, which is basically a 10% plus 2 rule. You get 10% plus 2 miles per hour over the speed limit, right? So if it's 60 miles an hour, 10% is 6 plus 2. We're really not going to pull you over until you're going at least 68 miles an hour, right? And that sounds to me like probably what is the rule in a lot of United States jurisdictions as well, although it probably varies from place to place. So step number one is that the police have a policy and practice of not enforcing the traffic code as written, but enforcing it, particularly with regard to the speed limit. It's very obvious, right, that there is a substantial buffer zone there. And then they turn around and, now this isn't the whole answer to what's going on in pretextual stops, but it's a piece of it, and it's a piece that is completely missing from Whren. There are some cases where they're engaging in a pretextual stop and the driver is driving 15 miles per hour over the speed limit. It clearly is a kind of violation that ordinarily we get somebody pulled over, and yet it still might be done for pretextual reasons, and there might be reasons to be objecting to it on the grounds of the actual motivation. But there's another large number of cases where it's simply a case of arbitrary law enforcement, arbitrarily enforcing rules that otherwise are not enforced. So in my view, Whren really does not discuss that at all. And to me, it's a starting point for trying to have at least some of the justices reconsider the basic premise of, well, can we really say to police, you're not allowed to pull somebody over for violating the traffic code or something like that? And the answer is to turn to the police and say, well, this is their policy, right? This is their decision of how they want to enforce the traffic code. My students find it hard to imagine, but we actually could have a system in the United States where you're not allowed to drive over the speed limit. That is within the choice set, the policy choice set that we could have, right? In a 60 mile per hour zone, you would just drive less than 60 miles an hour, right? I've never done it, but it could be done. Right? So, another way to kind of frame this same argument is to basically think about the entrapment defense, right? The idea of entrapment is that the police are encouraging or persuading somebody to violate the law, and that the person would otherwise not be predisposed to be violating the law. And when that's true, then there's a defense available to say, I'm not guilty here. And those same concerns underlying the entrapment defense are applicable here in the context of at least some of this traffic enforcement. I have two 13-year-olds who in a couple years are going to learn how to drive unless we get self-driving cars first, knock on wood. But my daughter, I'm confident, knowing her, when she begins to drive, she is going to drive under the speed limit. That's the kind of person she is, right? And it's going to take her a little bit to learn, and she will learn, that only suckers drive under the speed limit, right? She should drive, 3, 4, 5 miles an hour at least over the speed limit. And when she does that, she's not going to get pulled over, and she's not going to get pulled over if she drives right past a cop with his radar gun pointed at her, right? He's not going to pull over for that. So really what we have here is a form of entrapment, and the same underlying concerns exist. So that's my addition to this. And again, I want to emphasize recognizing that fact is not the whole story by a long shot. I haven't really said much of anything about the many issues that have been raised already about, well, what criteria are the police using in pretextual stops, right? And what are the motivations? And those are independently objectionable, and I think that's exactly correct. But a starting point is to recognize the inherent arbitrariness of a lot of what's going on here. And I think I will be curious to hear from Professor Lawton and others about the idea of an objective reasonableness test is really simply an argument by the court to simply hold the police to their own policy and procedure choices, right? That's simply what that test means. And I think viewed in that light, it seems much more intuitively plausible and, kind of normatively attractive. So I think I'll leave it there and turn matters over to Gordon, and then we'll be happy to hear questions about this.
You know, in many jurisdictions in Ohio, people are stopped for driving under the speed limit.
You're going too slow, absolutely.
Yeah, especially black drivers who are under suspicion at that point.
I mean, there's a Sixth Circuit case where, because there's just so much rampant, police sanctioned, violate the traffic laws. There's a Sixth Circuit case where, the officer also alleged that one of the reasons he pulled this person over is that her rigid position in the car with her hands at the 10 and 2 position, along with her failure to look at the police as she drove by, constitutes suspicious behavior, right? And frankly, I understand the claim from the officer there, because when the police do not expect people to be actually complying with the traffic law in a kind of punctilious way, and when you have a driver who is doing that, you either think they're a 16-year-old girl who just learned how to drive, or probably a somewhat savvy drug dealer, right, who has learned the only way that he can not get pulled over. But, so again, another way to point out, I think...
That's an oxymoron, by the way.
A savvy drug dealer?
Yeah, sorry.
Well, they're just not the ones who get you, who end up on your desk.
They all speed, and they all, either that or they're drive intoxicated. Trust me.
And then give consent.
Then give consent, thank you. Yep, absolutely. Johnny? Well, I also would like to thank you all, Ellen and the law review, for inviting me here. It's nice to be in the presence of so many smart people, and it gives me an opportunity and a pretext to hang out with my brother Lou, who I don't see as much as I'd like. So thank you, and I like being here. It's great, terrific and impressive symposium. Before I talk about civil rights cases, though, I would like to digress into their territory for a moment and just give you some more buzzwords. We're talking about profiling. We're talking about drug courier profiling. Those words are gone. The new buzzword is totality of circumstances. What all a police officer has to do today, he doesn't say the profile of, because that's, stupid talk. What all he has to do is talk about the totality of circumstances, and that plugs into the Constitution, and everybody's comfortable when he gives a series, look nervous, look down, look to the left, look to the right, or furtive motion and the like. Those are all buzzwords that get them past the verboten Reed versus Georgia drug courier profile. Justice Frankfurt, it's odd that I would quote him, has said that the history of American freedom is in no small measure the history of procedure. There no longer is a procedure, and the procedure is in fact the process, or the process is totally without any standards. Pretext is a result without a reason for all practical purposes. Also, before I talk about 1983, I would like to acknowledge the presence of some people who are really important to this community: Ed Little, Ronnie Dunn, Julia Shearson, and Dr. Rhonda are really, who are here today, are warriors for justice in our community. And it's not amazing that they're here today, because they're everywhere, and they're keeping law enforcement accountable, which is a struggle, particularly in the face of inept political leadership or a total lack of political leadership in the city of Cleveland. And that's why we have an order. It may not be followed, but we do have a nice little structure that, the fantasy is that it'll work things out and the police will improve, which I have high suspicion of. 1983, Section 18, 1983, certainly has been mentioned in many decisions you'll read as an alternative to the exclusionary rule, which has been totally emasculated by the Supreme Court, particularly in the Leon decision, good faith. And 1983 litigation, which I've been involved in, is civil litigation, and keep in mind that as civil litigation, it has some problems. Problems are today, Iqbal and Twombly, the two decisions really, that talk about precise pleading, and if you don't plead correctly, your case will be thrown out immediately, which means that you really have to do, which is impossible for the most part, discovery before you file an action. And the only way you can do that is through public records requests, which often will be rejected because of the matter is presently under investigation. For instance, if you have a homicide, a shooting, a death, it's difficult to get police records, police reports, until that quote-unquote investigation has been concluded. So pleading, 1983 cases have been very difficult to begin with. Summary judgment, for instance, qualified immunity, ancillary appeals, or appeals, collateral appeals rather, to the Sixth Circuit. The defendants, police, city, know that if they lose on summary judgment, they'll go to the Sixth Circuit here in Ohio. The Sixth Circuit is very, very friendly, almost the most part, to law enforcement, to municipalities, and that's where the defendants, feel very comfortable, and you never know when you have a judge who may be sympathetic to the plaintiff's cause. So it is a long road. It is an expensive road. So when Scalia and or his brethren flip off, well, you can go 1983 or equal protection, forget about it. 1983 is very difficult. There are successes, and we've been successful in our office. My partner in particular has been successful recently in the Smith case, and we were counsel, one of the many counsel actually, in the 137 shot case involving Tim Russell and Melissa Williams, who were shot 137 times for violating probably a traffic failure to stop, maybe, when they hadn't done anything wrong.
Maybe.
Yeah, maybe. Total maybe. Yeah, I mean, best case scenario, maybe. So, I mean, and that was a situation where the city really realized how badly they had done. Patrolman Brelo, who became a icon for shoot first and ask questions later, went to trial and was found not guilty by a friendly judge, quite frankly. And I'm one that believes that a defendant, in any case, whether he's a police officer or a drug dealer, has the right to waive a jury trial. So I can't fault him for doing that. It was a wise decision. It was a wise political decision for a defendant, police officer, to do it under those circumstances. And I thought in the Brelo prosecution of a police officer that the conclusion was totally predictable. I would have been shocked had it not gone that way. So 1983 is difficult. I don't see it as a remedy, quite frankly. I think it's a reasonable option. There are not many skilled lawyers that do these kind of cases. You could, at one time, throw together a complaint and file it, and you can't do that any longer with Iqbal and Twombly. You really, really have to have a lot of information. You should have an investigator out of the gate going out and trying to counteract the police investigation. Every time, and I'm talking about shootings mostly, every time there's a shooting, as soon as there's a shooting, the union is on the scene, and the shooter, police officer, is advised not to say anything, and he doesn't. He's got garrity, which is a decision that protects him from prosecution if he says anything, and then he'll be advised to be quiet vis-a-vis Miranda, which I totally believe in, but nevertheless is the case. Equal protection means that you have to go out, you have to get demography of the whole area, of the arrest. You have to do stuff such as what Ronnie Dunn does and get a profile of the number of arrests made, the number of the race involved, the number of shootings, and quite frankly, to make an equal protection argument for the everyday practitioner, it is really, really a challenge. It is costly. We tried to do it once and used law students from this law school on a shooting case, and we weren't able to bring it about. It got thrown out. Our judge wasn't impressed by the statistics that we tried to present. Fourth Amendment is still the route to go, but it's getting more difficult. So I do not see 1983 to replace Whren. Somebody asked at dinner, Jonathan, I think, is what is Justice Ginsburg thinking now, today, as a result of her decision in Whren? Well, the answer is Rodriguez versus the United States, which limits puppy searches on people that are just stopped for traffic violations. In Rodriguez, Ginsburg held, for the majority, that when you search stop a car for a minor traffic violation and you give them a warning, you give them the warning and let them go on their way, unless you have reasonable suspicion that otherwise there's something going on. And of course, racial profiling under those circumstances can play in. I had represented two men who were from Yemen, who were driving on State Highway Patrol. They were stopped for a lane change. Lane change. I mean, come on, a lane change. And the State Highway Patrol approached the car, looked into the window. Of course, you know, as I said, clients are not that smart. and the passenger had a wad in his mouth, and he looked like he was chewing tobacco, and he had this green stuff all over his shirt. And the patrol officer, state patrol officer, you know, got him out eventually and said, "What do you have?" And he said, "I'm just chewing food." Well, to make a long story short, it was a drug called cat, which is very popular, certainly in the Middle East. They make tea out of cat in Israel, and in Somalia, they chew it almost regularly. Kids chew it. But it's like a high dose of Starbucks. But it's a Schedule II drug, and they were busted eventually for drug trafficking, because they had money in the car, and they had a fair amount of cat, which, by the way, was old cat, which is not good cat, but that's neither here nor there. I mean, it's not very effective the older it gets. Anyhow, we challenged, filed a motion to suppress. I tried to argue racial profiling, which the judge kind of wondered what that was. And of course, I had a problem. The problem was that the patrol officer who stopped them and who I challenged for racial profiling was a very statuesque, 5'9", beautiful African-American female, probably the only one in the State Highway Patrol. But anyhow, my argument did not go over very well, but my client was diverted and didn't lose his citizenship, et cetera. So the fight's there. One thing that I've noticed in these cases, and I'm getting off I'll be happy to answer any 1983 questions you all have, but one thing I've noticed in all these cases, including United States versus Robinson, is the lawyers do not challenge the stop. In other words, they give in to the probable cause argument. Even in Whren, they did not challenge the traffic stop. And you absolutely have to challenge the traffic violation. What lawyers do is, you know, failure to make a turn, in Wren's case, failure to put on a signal, you have to challenge that. You may lose it. Lawyers generally think and say, well, let's get rid of the traffic offense, we'll plead no contest to it, pay a little fine, and move on to the more serious felony. Once you do that, you're in trouble. You have to fight the traffic violation. You have to say there's no probable cause for the arrest, and you have to fight it all the way. Otherwise, you're giving up your argument. I'll stop there. I'm going to lose my voice, and like my friend Michael, take it from there.
All right, so I'm going to sort of give us a where are we now, walk through what's going on out there, because we have in Whren the court taking away the Fourth Amendment and saying that as long as there is probable cause that a traffic violation has happened, a stop is always going to be valid. And so takes away that Fourth Amendment argument. And as Gordon explains, we've done a whole bunch of damage to 1983 to take away your ability to bring a 1983. And one of the big hindrances is, in fact, Whren itself, because Whren says there was probable cause, therefore it was a legitimate stop. And so any one client coming forward and saying, I want my 1983 litigation, comes in and says automatically with the traffic stop, I did commit a traffic violation, well, that's the end of your 1983. You automatically lose the 1983 by virtue of actually having committed a traffic violation, or at least having a more credible officer than your client say that there was a traffic violation. You have no violation of your 1983 rights because that one stop was reasonable. It's only if you go beyond and look at the systemic issues that you start to see the value of the 1983 litigation, and we can't get them to recognize the systemic problems. So where has that taken us? Well, I think there's a couple of main areas that we have seen an impact of Whren with the lack of valuable 1983. One area we have seen is in the idea of police tactics, that we have created a method of policing that has decided that the way to stop or prevent crime is to scare the public in particular communities, particular neighborhoods. So you start with broken windows. I think of this as the broken taillight method of enforcement. You over-enforce the traffic laws in a particular area, scaring the public in that area to being afraid of the police. And if they're afraid of the police, then they won't commit crimes. And we know this doesn't work, but it is the theory of policing that has dominated probably for the last 25 or 30 years, even predating Whren to a certain extent. So the law enforcement is using this in a way to try to prevent crime by mandating control, making fear. Another area that we see this is in the area of generating the right of the police to do fishing expeditions. And I tell my students that they should get in the habit of doing this. You should read your local community newspaper, not the big major one, but the local community. In Cleveland, we have the Sun newspapers, and then there's a number of regional communities. They all fill up space with the police blotter. And you need to read the police blotter to really see what it is that your law enforcement is doing. And I'm always amazed. I live out in Bainbridge, which is out on the eastern side, and there's a shopping area with a Walmart and Kohl's and Target, all that stuff, like every place else. And what you see in the police blotter is arrested person at Target for shoplifting. A search of the car revealed 50 pounds of marijuana. And so you see this type of policing connecting one crime to getting to the fishing expedition of getting to the next. And where do we see this with traffic stops? One of the cases we haven't talked about today is Robinette. Robinette is an Ohio case. Robinette is driving on I-75. It's a high crime area, known drug trafficking route. And the officer is sitting out there, and he is sitting near one of these construction zones that pop up every spring and last for years here in Ohio. And he's just pulling people over. Now, there's actually no indication that the officer is profiling race issues. He's just pulling people over. And so he's pulling people over. He pulls Robinette over, does the traffic stop on the speeding, and then before, this is where the litigation kicks in, before he lets Robinette go, says, "Do you mind if I search the car?" And Robinette stupidly says, "Yes," and then finds like one pill, and the case goes from there. What's in this case is that this officer testified that he had done traffic stops, and in the last year alone of doing this, and he admitted he was drug interdiction. He was not traffic enforcement. He was drug interdiction. Sitting out there, he had turned 786 traffic stops into consensual searches of the vehicle. So he uses the traffic stop, uses Whren to get the car pulled over, and then gets to consent and gets the search and gets the prosecution. We see this even in the other cases. Well, if I can't get consent, I get the dog. And before Rodriguez, they could keep you there for, 45 minutes, an hour. Oh, we're just waiting for the dog. And they would bring the dog, and then the dog gives them probable cause to do the search. So Whren is the predicate that gives law enforcement the ability to do things that they would never be authorized to do if they had to go and get a warrant, get authorization from a magistrate to be able to do that. The other part of it, and it flows along with Robinette, is the Dukes case that Jonathan mentioned. I actually happen to know the lawyer who litigated the case. He won in the district court, got the evidence suppressed because Judge Marbley just said the state troopers lying about everything. And unfortunately, it gets to the Sixth Circuit, and the transcript reads better than the testimony. So, on the cold record, it sounded reasonable. The officer actually testified that he didn't pull her over for some of the arguable violations that may have occurred. He pulled her over because the State Highway Patrol is a kinder, gentler police force, and he was going to educate her about the proper way to drive. And so he did this thing called an education stop. And fortunately, the lawyer, Harry Reinhardt, was the lawyer. Harry knew enough to do a public records request. He got the state trooper handbook, and he throws it up on the bench, and he says, show me in the handbook where there's this thing called an education stop. And there isn't anything called an education stop. But again, the Sixth Circuit gets the case, reverses the judge, not on the credibility issue, but on the basis of Whren. That the officer did, in fact, make a few statements that could have justified the traffic stop because it could have been a traffic violation, and therefore his real motivations for the stop don't matter. The traffic stop is valid, then the search of the purse, the drugs, everything comes in. So in terms of police tactics, we've actually encouraged the police to do this kind of conduct. Not for bad reasons. We can even just let's take out race, let's take out bad motivations. We've given them pure law enforcement reasons to want to do these types of things. Then you add the race problem or the race issues, and that's going to change the dynamics completely. The second area that I think we've seen a huge impact of this, and it comes in the equal protection issue, is in the community issues that the case has now started to generate. And that's where we start to see things like the disparate impact of the Whren on various communities. And so we see things like in Ferguson, where the first thing that sort of happened to break everything open about what was going on systematically in Ferguson was the Muni court judge resigned. Not law enforcement, not the cops, no, who's the first one to sort of run out of town being chased by the mob with pitchforks for racial discrimination? It was the Muni court judge. Why? Because they could go through and look and show that the municipal court was being used to disproportionately impact the African American community. So that's where you see that Whren is now leading not just to law enforcement stuff, but is leading then into the criminal justice system, resulting in municipalities benefiting from this disparate use of the statutes. And that leads to our new and emerging problem that's all been around for is the issue of debtor prisons, the issue of people being sent to jail because they can't afford to pay their fines, the revolving doors, places in the South where you have to pay to go to jail, and when you can't pay to go to jail, they put you back in jail and you incur more fines. And then there's this new one, you have to give blood. I love that one. You give blood or go to jail. And so apparently when you run out of blood, they just put you back in jail. This also then has led to the next real big problem that we're trying to figure out, and that is the community distrust. That people within these communities have been trained by this particular conduct to not trust law enforcement. And you end up with these very disparate discussions going on. You know, law enforcement comes in Cleveland, I think we're up to, 110 homicides already this year? Something like that. And one of the things that the police officers will say is nobody in the community will talk to us. Well, why will the community talk to you when you've got this disproportionate policing going on? You're afraid to talk to the police. My poor Crim Pro students, when we start the class, the first thing I ask is, how many of you have been taught to trust the police? Right? When you're lost, the first thing is find a police officer. They're your friend. By the end of my semester, they've sold their car. They've moved into the woods. They don't have an apartment. They drive down the road with their backpacks out the window. They don't take the Greyhound because they realize they have no protections anywhere except their house. And so we're going to teach the entire class by telecommute or something. If you have this distrust that law enforcement is actually the enemy, then the community isn't going to come to law enforcement when they actually need them to come in and do what they are supposed to be doing. Another component of this, and I've always waited for this case to happen because underlying Whren was the idea that everybody violates the law. Jonathan's idea, I pity him because my oldest just started driving, and we've had those discussions where she is driving below the speed limit. I'm like, go, go, the cars are piling up behind us. I'm like, drive, and she's like, no, no, I'm going the speed limit. You know, and I'm the passenger and I'm paying the insurance and I'm yelling at her to go. But, you know, the idea is you're going to violate the law. Well, along comes a case last term, Whren, where the police officer pulls the driver over because he has not yet committed, he's suspicious. I love the suspicious car. I don't know how a car is suspicious, but this car was suspicious. The cop pulls behind him, drives along, waiting for him to violate the traffic code, and he doesn't. Until he comes to a turn in the road, he taps the brakes to slow the car down to make the turn, and the officer sees that one of the brake lights doesn't light up. Probable cause, traffic violation, you have a defective brake light, lights him up, pulls him over, finds the drugs, goes to jail, the whole thing. Turns out the officer was wrong about the law. Under North Carolina law, this is how often they've updated their statutes. The statute read that you must have a working brake lamp. So I live in Amish country, so I envisioned the buggy with the lamp hanging off the back is what they wrote the traffic code for. You must have a working brake lamp. That is singular. He did, in fact, have one working brake lamp. So the ticket was invalid as a matter of law. So suppress the evidence because it's an invalid traffic stop. The case gets to the Supreme Court. Now, officers can't be expected to know the law. As long as they are reasonably mistaken about what the law is, then it's going to be a valid traffic stop. So you have Whren that says you need probable cause that a traffic stop has been committed, and now Whren, which says probable cause that you might have violated a law as the police officer believes it might be. His mistake of law is perfectly acceptable. But your mistake of law, or your violation of law, is not a problem. So you see these disparate impacts coming on with that. Another big component that we see in this, and this comes through in the consent decree here in Cleveland, is that Whren has created a police culture. There are communities in which, I'm sure if Dr. Dunn does his study, is not going to find the same magnitude of problem. I think the problem is going to be there no matter what the data sample is, but you're going to find communities in which traffic enforcement is almost non-existent. I happen, like I said, I live out in a semi-rural community. Our police department we're webcast, right? Oh, well, I get myself in trouble all the time anyway. Our law enforcement, they don't
have television.
Not out there. You have to go crank the batteries. Our law enforcement don't enforce the traffic laws unless you're really bad, like dangerous bad. And there's a couple of reasons. One, most of the people driving in our community or through our community are from the community. And when you're from the community, what do? You vote for the police levies. So the police they don't get an incentive to piss off the public by giving them traffic tickets because they're going to come to them every couple of years and say, we need new shiny police cars, give us a levy. And if you're angry because you got a ticket, you're not going to do it. Another component of that is they don't get any revenue. The revenue from traffic tickets doesn't come to our community because we're not big enough to have our own muni court. So the ticket revenue goes to a different jurisdiction. Well, if we're not getting any money for the traffic tickets, why enforce it? You go to other communities and the traffic enforcement goes way up. And you see a disproportionate number of tickets being written. So now, in Jonathan's case, not only is this officer having discretion to pull you over or not, in your community differences. This community, you will or won't get pulled over depending on that. In other communities, you won't get pulled over. So you end up with this police culture issue that leads to a culture of enforcement or non-enforcement that can, in fact, then come back to the issues of racial bias and racial prejudice. I think another couple of issues is, as Gordon mentioned, the issue of immunity. Even if we can prove, I tell my students the sad part about Whren is a police officer under Whren could come in, raise his hand, swear or affirm to tell the truth, the whole truth, and nothing but the truth, and say, yes, I pulled that person over because he was black. But he also didn't turn on his turn signal when he turned, and the judge says, evidence comes in, go to prison. because the objective or the subjective motivation of the officer doesn't matter. And you still lose the 1983 case.
That's true. Can I interrupt for a moment? To the extent that in Whren, the majority, the entire court, rejects the reasonable police officer standard, which Whren proposed as an option to the objective standard, yet in the absolutely classic landmark case of Katz versus the United States, Justice Harlan, in a concurring opinion regarding reasonable expectation of privacy, goes to the reasonable citizen's expectation of privacy and is not troubled by imposing that standard. That is, what would the reasonable citizen believe to be his expectation of privacy? So on one hand, in Katz, they rely on this kind of generic subjective intent, but in Whren, they're unwilling to impose it. And I think that is a remarkable contradiction in terms of the philosophy of the Supreme Court at the present time.
Are you ready for the free-for-all?
I got one more thing.
Okay.
I'm sorry for interrupting.
That's all
Jerry.
right. So the issue in immunity always brings me back to the Ford Pinto cases, that cities have made sort of the cost-benefit analysis that it's cheaper to pay off the victims of bad police than it is to actually change the police. And then last thing is, one of the easy fixes for Whren is to do the opposite of what Jonathan points out is happening, is let's enforce the traffic code to everybody. Just pull over more white drivers, right? It's the solution for the racism and the death penalty. Let's just kill more white guys and that'll cure racism. I think we already know where that's going to go, because traffic cameras are, in fact, non-racial. They don't go off based on the color of the skin of the driver going by. They go off because the violation happened. And where are traffic cameras? Voted out by the public. Because the people who were getting tickets were people with political power, and therefore they voted them out, because they don't want to have to be subject to the traffic stops that happen with Whren. Am I okay? 2 minutes. I cede my time.
You can have my time.
Okay, we had agreed that after these three wonderful presentations, we'd have a free-for-all and then involve you folks in that free-for-all. I think we've all left Terry off the hook.
Oh, yeah.
Oh, yeah.
We talk about Whren, but Whren is not just probable cause that a traffic offense has been committed, but reasonable suspicion that the tint level exceeds the legal limit. So it's not even probable cause. It is that almost open, unlimited notion of reasonable suspicion. That's my number one.
Well, Whren is really Terry gone amok. I mean, and Terry's gone amok to begin with.
Right.
Yeah.
Right. And every 10 years, I change my mind about Terry.
Do you really?
Yeah.
Oh.
It keeps getting worse.
My uncle decided it originally.
Secondly, you raised the point about your cops don't stop people unless the conduct is really bad. And that issue is raised in Whren as well. Scalia reacts to the petitioner's claim that there are so damn many traffic offenses, everybody is committing traffic offenses. And I remember when we used to teach cops here and have a cop shop, I remember some of the young hotshot cops saying, I can pull anyone over for 10 reasons within 5 minutes. And it's because there are so many traffic offenses. And in Whren, they had the possibility to limit the pernicious effect of their own decision by saying, we will allow you to pull over people for traffic offenses no matter what your subjective intent is, motive is, so long as there is a protection aspect to the violation. a safety aspect. And they reject that he rejects that, Scalia rejects that out of hand. And you keep wondering, where is Ginsburg? Where is Stevens? Where are they?
Sleeping.
Sleeping.
In the patrol car.
Yeah. Yeah, they went on the ride along. And actually, what's interesting is that was part of the litigation in the Dukes case. I add that into my syllabus and make the students read the district court opinion, because it's so great. One of the things in Ohio, one of the alleged violations that Ms. Dukes committed was she was driving too close to the truck in front of her. If you've driven down behind the semi-tractor trailers, you know that they go along at 100 miles an hour until they hit a grade in which they then drop down to 10. If you're not paying attention, you end up being cargo. The Ohio statute regarding following too close is very vague. It's following too close for conditions of the traffic and of the driver. And so what does that mean? That the officer believed that she got too close to a tractor trailer in front of her and admitted that the tractor trailer had hit a grade, had slowed down, and so she did get, in his opinion, close to the truck before she slowed back down. And one of the reasons that Judge Marbley suppressed the evidence was he found that the officer had no way of knowing whether or not Ms. Dukes was in fact Danica Patrick, with cat-like reflexes that could zip out of the way of the truck, or any example of what was the vehicle, what was its maneuverability. I always remind my students of the Autobahn in Germany, and they all think the Autobahn has no speed limit. And in fact, they do have a speed limit. It's safe for your conditions of you as a driver and for the vehicle you're driving. So you're driving a Ferrari, you can go 180 miles an hour. You're driving a 1967 VW Beetle, you might have to go 10. You know, that's all what's going to be there. So yeah, in fact, the enforcement has become completely discretionary. The statutes are discretionary, and you lead to this idea that anything's going to get you pulled over for anything you do. I do think one of the concerns the court had, a legitimate concern, is if we say, well, it's got to be a dangerous driving violation, well, what's that? Is it 5 miles over the speed limit, 10 miles over the speed limit, 20 miles? And you know what we're all going to do. As soon as the court says 5 miles an hour over is the speed limit that they can pull you over, Jonathan's example comes in, well, now I'm going to go 10 over because that's only 5 over the 5 over. And then it's another 5 over, and pretty soon everybody's driving around like crazy people. I don't know how, I think the court couldn't figure out how to fix it.
One final comment before we open it up. And this may really take the symposium off the rails.
Take it.
You talked about totality of the circumstances. Why doesn't the totality of the circumstances test apply to the use of police deadly force? Why is the Fourth Amendment issue of justification only that moment when they fire the gun,
It's segmentation is what you're
rather
talking
than
about.
their entire approach to the kid wielding the gun in the recreation center?
Right. It's segmentation. They only take it up to the very moment because because of case law, primarily on the Sixth Circuit, do not take into consideration police misconduct. Brandon Robinson case in which our client was shot dead in his bedroom in his skivvies, and the police were looking for him. They had a search warrant for his house, and they did a bunch of things. Their entry was unlawful. They didn't give proper notice. They were in full equipment. They ran up to his bedroom and opened the door and shot him dead. Brandon, it was called Chappelle versus City of Cleveland. Terrible decision by the Sixth Circuit, with a decision I think was written by Karen Nelson Moore, or at least she was part of the panel. And they took everything that happened before the final shot as not being relevant to the final moment, and that is the totality of circumstances, which has been totally rejected. And I don't have an answer as to why they don't use that. They should. And it would certainly be much more useful for plaintiffs in those situations if everything was looked at, but everything is not looked at according to the decisional law in the Chappelle case, which is Sixth Circuit, and other jurisdictions likewise. I mean, they call it segmentation, and they reject everything up until the moment. And in that moment, the kid had a steak knife out, he's holding it like that, and two officers in full body gear, totally drilled him in his own bedroom. And it was thrown out. Judge O'Malley, a graduate of this law school, wrote a brilliant opinion denying summary judgment, and was very, very thorough. And the Sixth Circuit just blew it right off.
Okay, thank you. We're ready for your involvement.
There's been a lot of talk about culture and things like that, but this assumes that the whole system, it rests on logic. We can start with the first sentence of the common law from Justice Holmes, but I guess my question is, given the sense that we have a crime problem, whether it's a general crime problem or one that is confined to certain disfavored groups or communities, and given that state judges are elected and federal judges are people who knew senators, why should we expect the courts to get all that far from where the public may be? And these days, there's a lot of folks in the public who think that things are hopelessly out of control.
So, I mean, I can't fundamentally answer that, but I have a few things that I also thought of these when Gordon was talking about. Part of this is, what do we know? What's the information that we know? What's the information that our political leaders are, and the judges, frankly, are using to act on? And so as Gordon explained, he's got to do discovery, and he's got to get Professor Dunn to run 100 studies before he can even file a lawsuit. He's got to learn all of what he could get in discovery before he can even file his complaint.
Or even before I can ask for discovery.
Right, correct. And I think a big piece of that then is the basic observation that we have the statistics that our political leaders are interested in knowing the answers to, right? I don't have the information off the top of my head, but I could tell you in the city of Cleveland, the number of violent crimes, the number of property crimes over the different years, what the trends are. I could tell you the, racial and gender profiles, of who committed those crimes, because that's all recorded, right? We have all of that data. I think maybe, the municipal court judge in Ferguson, the real problem there is that we keep records of what municipal courts do, and so once we looked at it, we could learn what was going on. If you ask me how many Terry stops are done every year in the city of Cleveland, I don't know, and nobody else does either. If you ask me what's the racial breakdown of the Terry stops in the city of Cleveland, I don't know, and nobody else knows either. And so why do we know, it's 2015, come on, right? Why do we know certain hunks of data? We've been keeping track of it for a long time, and other pieces of data that are obviously relevant to really important policy questions, well, we don't know, right? We just don't know what's going on there. And we don't know, I think, because I guess we don't care to know, right? We're not trying to find the answers to those. We're not tracking it.
There was legislation introduced in the Ohio, I think it was the Senate, by a member of the delegation from Cleveland, twice in the 90s, asking for record keeping by the State Highway Patrol of all of the stops that they made and the characteristics of the people driving the vehicles and the outcomes. Never got to a vote. It never got to a vote. Why? because obviously the highway patrol didn't want that information collected, and the politicians reacted to the highway patrol and didn't want it either. And so it's a universal problem. Now, one thing Michael said earlier about police, the community unwillingness to cooperate with the police. And surely that's true. But there's also a phenomenon which exists in Akron and is now growing in Cleveland, where people who are witnesses to crime are afraid to testify and come forward, more so because of the criminals than the police. And I think you gotta recognize that.
Well, and this is not, there's no one problem,
Okay,
I think,
but you
going on.
made it sound like
Well,
one.
there is. I mean, it's always the police fault. So, I think first off is, when is crime not a problem? It's always a problem. It's always going to be a problem. We're always going to have it. And there's nothing we can do to eliminate it.
Any crime is too much crime.
as long
even
as I'm
though-
the victim.
Even though we have the lowest crime rate
Right.
in the last 30 years in this country.
The other part of that is, in terms of not knowing the information, the first thing that guys like Steve Loomis say when you start talking about this, and it's talking about use of force cases, talking about collecting this data, is that you are going to deter the police from doing their jobs because they're going to be afraid of what is going to be shown. Now, he phrases that as, we're going to be doing things right, but people will misunderstand what we're doing. And therefore, we will be afraid to do our jobs because people will be looking at us. I mean, think back 10 years ago, when people first started carrying cell phones with cameras, a number of states passed statutes and initiated prosecutions for recording police officers. It violated the Wiretap Act of certain states, or they've had special laws that you can't videotape the police and use, I mean, all this kind of stuff that was designed. Now we're switching around. We want body cameras. You got legislators tumbling over themselves to spend tax dollars to buy cameras for law enforcement. And law enforcement, many of them say, give me a body camera and it'll show I'm doing things right. But other people, and like the union leaders, say, we don't want body cameras because it will misrepresent what actually happens. In terms of use of force, I mean, the problem with use of force is going to always look ugly. There's no nice looking use of force. I mean,
Well,
even if it's appropriate.
Probable cause is the standard for use of force, and it doesn't work. It just doesn't work. Tennessee versus Garner and the use of deadly force decisional law today, in the context of today, Ferguson, Tamir Rice, the 130 shot case, doesn't work. It is not operable any longer. We need new standards.
Thank you. First, I'd like to thank all the panelists today. My perspective has been changed for the better, I think. But my first question, or my only question is, I know as lawyers and law students and professors, we think all these problems need to be solved in courts. But if there's one thing I learned from Professor Benza, it's that criminal law is a matter of social policy. And what would be your recommendations to encourage better people to become police officers, particularly people from my generation?
Well, you know, part of the problem with the police today on their streets, and this isn't going directly your problem, is, and I recognize and applaud it, is that many of them are former military people. And I think it's wonderful that we're hiring our vets, quite frankly, when they come back. The problem is that when they go out on the streets of Cleveland, they're really going out on the streets of Fallujah and Kabul and other dangerous areas, and they treat the city's streets as occupied territory. So maybe more law students, if you're asking the questions, how do we get better police officers? You all should go and become a police officer for 5 years as like the Peace Corps. Join the police department. Instead of going to the Peace Corps, nobody goes to the Peace Corps anymore, I'm afraid, but they should. go out and be a police officer for 5 or 6 years before you go out and practice law.
And if you do it right, with overtime, you actually pay off your loans better than being,
And
being a prosecutor or a public defender.
And if you go to this law school, it sounds good.
What's happened to our IT people?
If you go to this law school, you'll be driven into deep debt.
And,
You know, that answer is all well and good, but
Oh,
it's
no,
not,
it's not.
it's not realistic. You're not gonna have law students becoming police, and I don't think we need to do that. I think the problem is in the political leadership. The problem is in the acceptance of illegal policing. And that's a political issue. And that's where we have not made the effort.
Well, for example, New York City is doing a new training program to try and create cultural sensitivity, and one of the things they're doing is having their new, and all officers, watch the autobiography movies of Anne Frank and Emmett Till. And they've interviewed these officers, and the officers all say, oh, I knew all about Anne Frank, we read the book in school, I knew all about all this, never heard of Emmett Till. And it's like there's that disconnect between the people who are coming into law enforcement and some of the communities in which they serve, of not understanding a historical connection between law enforcement and the community's attitudes about what police are doing. So it isn't getting better people to be cops. I know cops. I have cops in my family. They're nice people. What you have to get is to the idea of what is it like to be a cop? What does it mean to be a cop? And how do you do it so you protect your community, but you respect the rights of everybody? And that's where the problem is.
And I think that you're right that the courts have a role to play here, but are not really fundamentally the solution to this. With the Cleveland consent decree, you know, it remains to be seen how that plays out, as Gordon said. But what you see in that decree are some, you know, attempts to make fundamental institutional reforms in the institution of the Cleveland Division of Police. How are they trained? How are they held accountable? How are they instructed on what the policies are? You know, those things are critical. And, you know, an officer who's working in an institution, like any of you, in an institution which is a dysfunctional environment where there's no accountability and nobody gets trained on how to do things, that's no place to work, right? That's no place to be able to do a good job in what you're doing. So I think those institutional reforms are really critical. And one of the, spoken a little bit about community distrust, one of the most startling, you know, stark things that I feel like I've seen, you know, in the last couple of years with the Department of Justice report on the Cleveland Division of Police and various other things that have come to light is apparently the Cleveland police officers do not trust our local criminal justice system to handle things and adjudicate them correctly, right? Because you'll have the DOJ reporting how we have an incident of some, you know, police chasing some guy, they get him, and one of the police officers is kicking the guy while he's on the ground. But unfortunately, we don't know who that officer was who did that, because none of the officers present will tell anybody who it was. That's police distrust of the system, right? And so the police themselves, I think, are illustrating that they do not trust you know, these systems to work fairly and neutrally, and I think it shows us we have a kind of deeper institutional issue here.
So one final comment on this. The absurdity of the amount of money that is paid out because of police illegality, you would think would motivate the political leadership to insist that the police leadership exercise control and bring the police within the law. But that's all over the country. That's not just here.
And it's
But there's
other-
no, but there's no political leadership.
Right.
That your premise is based upon. And in the city of Cleveland, I do not think that the mayor gives an iota, those of you may want to defend the mayor, but does not give an iota about what's going on, even though it's costing him money and now embarrassment with the DOJ report. I just don't think he cares.
And it's other things. I mean, the first thing you should do, if you want to change this idea of the police, get rid of the Chargers and the black cars and the blackout windows. You get rid of those intimidating cars. Ban black gloves. The first thing Cleveland police officers do when they get out of the car is pull on these black gloves. Now, why do you need combat gloves to do a traffic stop? First thing a state trooper does when the state trooper pulls you over, gets out of the car, leans in, pulls out his Smokey the Bear hat, straightens it up, pulls up the tie, walks up to the car. Excuse me, sir or ma'am, do you understand why I pulled you over? Cleveland police, pull on the black gloves, come up, pound on the window. Do you know what you did? Why did you do it? Did it? You've changed the entire interaction. You know, I live out in the boonies, out in the country. Our chief, first, a couple of things. One, our police department, in 40 years that we've had a police department, never once have they fired their guns. They've been shot at, they've been dog attacked, never have they fired their guns. All right? We started authorizing new vehicles in our police department. The chief came in and said, I don't want Chargers, I want Ford Edges. These are the cars I want. And I want them pale blue, and I want them, I don't want these other things. Cleveland cops, that's what they want. So you've got these cultural disconnects. So it's not just this, who is the officer, it's the culture, the identity, the theory of how the police are going to be run. So.
I'd like to thank all of the panelists for their insightful comments. In that we've discussed how Whren arose in the context of the war on drugs, I'm curious to know, how do you see Whren being applied in this current drug epidemic relative to heroin, if you do in fact see it being applied at all, if any of you could address
Just
that.
opens more doors. I mean, Whren applies to cars, Terry applies to people on the streets, and Leon applies to houses, and put them all together, and it's open season on the other person. I mean, and that'll be a rationale. Heroin is a deadly drug, unlike marijuana, which has been the kind of pretext for a lot of stops these days and arrests. Heroin is worthy, but I think the police have all the tools they need today with the case decisions, including those cases I mentioned, to do whatever they want. The sanctity of the home is no longer great, whether it be the apartment or otherwise. But all a police officer has to do is flash good faith, and you forget a warrant. Warrant may not be necessary. They've expanded exigent circumstances to a point where the police can create their own exigent circumstances to go into a house without a warrant and be justified. There's no knock and announce for all practical purposes. So heroin is a problem. It's a huge health problem, by the way, more than a law enforcement problem, but that's another story. I think the courts have given law enforcement carte blanche to do whatever they want, period.
Well, and heroin's not new. I mean, we can track the crime. You can track through the Supreme Court the drugs of choices of the eras, because we have the 50s and the 60s, and what are the drugs? It's heroin.
Heroin's back.
The 80s, it's cocaine. The 90s, it's crack. Well, we're just back to heroin. So it's just the cause of the day that justifies what they're doing, but they're going to do it anyway.
Also, there's by the way, there's an opportunity to diminish pretextual stops and arrests, and there is on the ballot a very troublesome but necessary issue 3, which legalizes marijuana in the state of Ohio, and there's also a more so troublesome issue 2, which allows for monopolies vis-a-vis the Constitution. And people are troubled over that. I accept that, and I understand why people do not like the idea of a monopoly to get through the door of legalizing marijuana. but if you legalize marijuana, the number of pretextual stops will diminish, period.
You know, I'd like to get in on that too. First of
You
all,
can't, forget it.
first of all,
They also want us to wrap up.
I'd like to correct what you said about issue 2. Issue 2 would prohibit monopolies.
Correct, that's what I
And
meant.
the problem is, if you pass
would-
issue 2,
Which would,
you have no referendum process in the state of Ohio any longer, because the only way for people to change the law is through the constitutional changes, and the only way you're going to fund constitutional changes are by people who have an interest and create these monopolies. But finally, I'd just like to say, and I meant to say this in the beginning of the session, Gordon reminded me by bringing up issue 3. Gordon Friedman has been a pioneer in changing the law on marijuana in this country. He was one of the leading founders of NORML
correct?
back in the 1970s, when everyone tittered about NORML, and now it's the reality, and hopefully Ohio voters will recognize that and not be misled by issue 2, which is intended to
To
mislead.
mislead, right, thanks.
Do we have a final question? Yes?
Just a final comment to the question from the gentleman back there about what to do about police departments and police, how to have better police. I think you're right, Professor, that it can't just be about individuals, but on the level of individuals, recruit for values and proof of values in experience. Too often we recruit because somebody was in another police department. It saves us on training costs, and that's almost always, it turns out, a mistake, because why'd they leave the first department? Number 2, remove bias from the recruiting process. We had, in Pittsburgh, have just settled a long-term case in which we're trying to root out the bias from the recruiting process that kept our population of African-American recruits very, very low. And all along, what we would hear is, oh, the recruits aren't out there. We can't diversify the police department. Number 3 is that they should learn their own history. Emmett Till was mentioned, Anne Frank was mentioned. What we don't have in either the academy or in-service training is history of law enforcement. It's law enforcement that's been the tip of the spear for Jim Crow, in the 50s era, for all the, who came in and arrested the people at the lunch counters, after all. They need to know that things have not always been on the right side of history. I think if you do that and you combine it with real accountability measures, which you all are now experiencing for the first time, perhaps here in Cleveland, maybe under the consent decree, what you're looking for is a complete change in culture. It's a difficult thing at best. I agree with Gordon, it's going to be hard, but that's the way.
How true one of your comments is, the fact that we hire people who failed in other departments, which is the case we're
Tammy
living
Rice.
with right now.
That's right.
I want to thank this panel. Great presentation, toughest subject of the day, and I really look forward to the 2 panels this afternoon. Now, if the law review would take control now and
What do we do now, Ellen?
tell people lunch is across the hall. And thank you.
Great, thanks, Michael.
Yeah, me too.
Fun.
Are you going to stick around?
Yeah, I'll stay for at least one more, and then I don't know what I'll do. I'm impressed. I think this is a wonderful symposium. Obviously, I only see one. I don't see any practicing lawyers here. There may be some.
You don't see what?
The practicing
Practicing
bar.
lawyers.
No, there's none here.
Oh, thanks, Dan.
You, thank you. It's a great compliment.
Oh, yeah, right. For
I
as
think-
free a society as we claim to be, we're the most heavily regulated.
Yeah, totally agree with
Gordon made a
that.
comment just a minute
Totally
ago.
agree with that.
He said, I don't see
think
anything
that,
from the practice
there are
in
too many
law."
laws. Laws
Well,
don't,
you're
and,
here.
and rules and penalties
you're
don't
retired.
always solve the problem.
It's
I mean,
amazing.
whenever there's a problem,
This law
there's a new
school
law, a
puts
new
on
crime
programs
that create
and the
new
bar
crimes. And we
fills
don't
the
need-
seats.
I
That's
mean,
not the
yeah, I
case
think that's part of
today.
the problem. I do. I totally do.
Yeah,